All right, welcome everyone to the Tuesday night keynote speaker for Social Justice Week, Dr. Al Gedicks. Sorry.
The microphone. Thank you all for coming out. Is the microphone work?
Yeah.
Thank you all for coming out on a not so great weather day and being a national election day as well. I appreciate your extra effort. I hope I won't disappoint. I will start with an Indigenous acknowledgement that we are on sacred land. We acknowledge that the University of Wisconsin-La Crosse is located within the ancestral territory of the Ho-Chunk, Sauk, Sac Fox, and Potawatomi. We also recognize that Native Americans had mined this region for thousands of years, and exporting lead had become an important part of the Ho-Chunk economy. By 1828, there were as many as 10,000 illegal settlers who seized the lead mines from the Indians and provoked the Winnebago Revolt of 1827 and the Black Hawk War of 1832. The Black Hawk War ended in August 1832 with the massacre of roughly 1,000 Indian men, women, and children at the Bad Axe River by U.S. Army troops as they attempted to cross the Mississippi River south of La Crosse. The Ho-Chunk experienced their own version of the Trail of Tears as they were forcibly removed from their traditional lands in Wisconsin multiple times, beginning in the 1840s and continuing until the final attempt in 1873, 1874. Each time they returned to their traditional villages in Wisconsin, including the area of present-day Riverside Park in downtown La Crosse. So tonight's presentation is really a summary of a lot of my work over the past 40 years, actually, since 1976, when I was first recruited by the Mole Lake, Secaucus, Chippewa to assist them in their opposition to a proposed underground copper zinc mine promoted by the Exxon Mining Corporation in 1976 that would have destroyed the water that flowed into their Wild Rice Lake, which is the reason why they were located at that particular place in northeast Wisconsin, outside the city of Crandon. This is a photo of one of the demonstrations against the proposed Exxon Crandon underground zinc mine at the state capitol that brought together the 5 tribes that were in a direct path of the contaminants of the mine. And that includes the Mole Lake, Secaucus, Ojibwa, the Potawatomi in Forest County, Stockbridge, Muncie, the Mominee and the Oneida tribe, and eventually the surrounding non-Indian communities. It was the largest interethnic alliance against a destructive mining project in the history of Wisconsin. Where's the no.
Yeah. There you
go. Oh, okay. In order to understand the context for not just this particular project, but a lot of the resource conflicts involving the extractive resource industry that affects Native peoples around the world, I put up these figures from an article on resource wars. And the basic idea here is that on a worldwide basis, the mining industry is extending the resource frontier into remote areas where there are untapped reserves of minerals. In fact, the vast majority of the remaining world's minerals happen to be located on the lands of native peoples around the world. Indigenous territories and communities are at the leading edge, thus, of the extractive resource industry. In order to understand the reasons why this is such a controversial and conflictual issue, all you have to do is look at the statistics. Nations account, that is, we're talking about indigenous nations, all these native peoples that constitute, by virtue of their occupation of territory, their control of resources, their form of government, all of them are defined anthropologically as nations which are sovereign over their territories. Those nations account for 10 to 15% of the world's population, but have traditional claims to 25 to 30% of the Earth's surface and resources. In other words, after the colonial period, when native people were pushed onto these pieces of land called reserves or reservations, those were a fraction of the traditional territories occupied by these native populations. Their traditional claims extended beyond those narrow boundaries called the reservations into their traditional territories where they. So that explains that 25 to 30% of the Earth's surface and resources. And this is one of the major reasons for the conflict between nations and states, whether we're talking about within the United States or around the world. Contrary to conventional wisdom, the racial ethnic confrontations during the Ojibwa spearfishing controversy, which extended over a 10-year period from the mid-1980s to the mid-1990s, and resulted in a lot of antagonism and conflict between Ojibwa spearfishing tribal people and the non-native populations in northern Wisconsin. That conflict was transformed into environmental cooperation, where non-Indian towns came to see Native American sovereignty and treaty rights as an effective legal tool to protect their communities and a common watershed against mining companies. I talked about the Exxon Grandin project threatening the Mole Lake Reservation and the wild rice. And so, as a result of this conflict over spearfishing, where misplaced responsibility was placed upon the Ojibwa for overharvesting resources, the outcome of that spearfishing conflict provided important lessons that the real conflict was not over overharvesting fishery resources, but the contamination of those fishery resources from the discharge of pollutants from the proposed Exxon and other mines being proposed in northern Wisconsin. And so those towns came to see Native American sovereignty and treaty rights as an effective legal tool to protect their communities, again, a common watershed against mining corporations. So you see the headline here, old foes, now allies. The foes were the people that were at odds over spearfishing and the misplaced responsibility on the tribes for overharvesting the walleye. They were actually harvesting less than 3% of the total walleye, while the non-Indians were harvesting 97%. So a lot of the people who were involved in that conflict began to be educated as a result of their involvement in the conflict, that the real threat to the resource was not overharvest of the fish by the Indians, but the pollution from the proposed mining operations. Thus, old allies are now allies. No, old foes are now allies. And this is one of the banners that promoted the idea of sulfide mining as the major threat to the clean waters and the fishery and the tourism economy in northern Wisconsin. So the Crandon mine conflict, which extended over 28 years from 1976 to 2003, became a turning point in 1995 when the Mole Ojibwe won the right to regulate water quality on their reservation. And this is where the whole notion of sovereign nations comes in, because it is only sovereign nations that have the ability to act as states in regulating water quality, just as the state of Wisconsin, it has the ability to regulate water quality on its lands. And native populations, after 1995, were recognized as having that sovereign right to regulate water quality on their water quality that flowed through their reservations, that involved upstream polluters like Exxon that would have discharged pollutants into the waters that fed the wild rice lake of the Mole Lake Sikagan Chippewa. And Mole Lake, which was the pivotal tribe in this legal recognition of their right to exercise water quality standards to protect their wild rice, became a source of controversy between the state of Wisconsin and the Native nations. Attorney General James Doyle, who was the attorney at this time, sued the Environmental Protection Agency to prevent the Mole Lake tribe from exercising their right to regulate water quality on their reservation. And they delayed that decision through court battles over a 7-year period from 1995 until 2002, when the Supreme Court refused to hear the lower court decision that affirmed the right of the Mole Lake tribe to regulate water quality. And of course, if they can regulate water quality as it enters the reservation, they could set standards, and they did set standards that protected the waters that flowed into their wild rice lake, and thus the reason why they were at a particular place in northern Wisconsin. This same interethnic alliance between Native nations and the surrounding non-Indian communities became the basis for a joint lobbying effort in 1998 that resulted in the passage of the mining moratorium law, also known as Prove It First. The mining industry has famously said that they can conduct mining in a sulfide mining environment without contaminating the local water supply, the groundwater and the surface water. What the mining moratorium law said is that, fine, this is what you say, prove it, show us. One example in the United States or Canada where you have mined in a sulfide ore body without contaminating groundwater or surface water, and if you can show us where you've actually done it, then you can get a permit. If you can't show us where you've done it, no permit. That's the whole meaning of prove it first. And that effectively shut off mining proposals in northern Wisconsin for the next 20 years. This law was passed in 1998, and in 2017, the mining industry and the Republican Party joined forces to overturn and repeal the law that protected Wisconsin waters from unregulated sulfide mining. But at the time that it was passed, in 1998, the Mining Environmental Management Journal, which is an industry journal, said in 2000 that the political movement responsible for this landmark environmental legislation was an example of what is becoming a very real threat to the global mining industry. Anti-mining activism was recognized at that point as a global social movement. And so Crandon and the battle over the proposed Crandon mine became the turning point, not just for Wisconsin, but for the international mining industry, who understood that grassroots environmental alliances with Native nations was a powerful force that needed to be taken into account in any future encounter between the international mining industry and indigenous populations. after 28 years, beginning in 1976 and culminating on October 28, 2003, the Mole Lake Ojibwe and the Forest County Potawatomi purchased the 5,000-acre Crandon mine property, ending a 28-year battle to protect the headwaters of the Wolf River from sulfide mining. So not only did they defeat the particular project, but they essentially created a political situation where it became impossible for any mining company, Exxon or any other mining company, to go ahead and develop that project. And so the value of the minerals essentially were zero. That's why they were able to purchase the entire property plus the mineral rights for $16.8 million, which was a fraction of the value of the minerals that were underneath the deposit, underneath the waters of the Wolf River. And so they set a precedent for not only defeating an international mining company, actually 4 of them in succession, but they also then declared the 5,000-acre property as a cultural resource area that would be permanently off limits for any future mining. And so it was a major international precedent. The Bad River Ojibwe learned from Mole Lake's experience, and in October 2011, they won the right to set their own water quality standards to protect water entering the tribe's wild rice beds. The reason why this was so important was because between the defeat of the Exxon mine in 2003 and the achievement of water quality authority by the Bad River Ojibwe, who had a reservation on Lake Superior that contained the Great Lakes' largest natural wild rice lakes in the Great Lakes, that was being threatened by a large-scale iron mine. That water quality authority allowed the Bad River Ojibwe to enact the same kind of protections as Mole Lake had established back in the 1990s. And so Tribal Chairman Mike Wiggins in October 2011 announced from just north of the Pinocchio Mountain area, Pinocchio Mountain is where the iron ore resources would have been extracted had there been a mine there. And there was no, and there is no mine there because of that opposition. From the north of the Pinocchio Mountain area to Lake Superior, our tribe is ready to stand up and protect Nibi, which is the Anishinaabe word for water, for all people in future generations. Again, announcing that the legal and treaty recognition of their sovereign right to protect water was not just going to protect the reservation wild rice beds, it was going to protect the water that flowed from the Pinocchio Mountains down and eventually into Lake Superior, and then all the communities around Lake Superior, including Ashland, Bayfield, and all those small towns between Ashland and Lake Superior. In February 2015, 2 years after Governor Walker signed a controversial iron mining law designed to speed up mining permitting, Gedicks Taconite, which was the company that was proposing this large-scale iron ore mine, pulled the plug on the mine because the project was not feasible, citing, quote, unexpected wetlands at the mine site. This is the first time in the scientific literature that the term unexpected wetlands has ever appeared. The wetlands, of course, were not unexpected. Activists, poets, musicians, and members of the entire community spoke out, reading poems at meetings, vigils, and other gatherings. We saw the entire county board go from being in favor of the mine to being totally against it, according to poet Rob Danson. His poem, High Noon at the Sioux River, I'm loading my pen with invective again, screaming truth to power, protecting the hills they want to devour, with explosives and warp and vast machines that scoured the earth for iron and gold. And this photo of an armed security guard in camouflage with an automatic rifle was what the company, Gedicks, brought into northern Wisconsin for the first time in the history of the state of Wisconsin, where a mining conflict became militarized to the point where the mining company, fearing public opposition to their project, imported armed security guards that were, up until this point, only seen in countries in Central America where there were open conflicts between local indigenous communities and mining corporations that resulted in the import of mercenaries and militaristic responses to community protests that involved the assassination and surveillance of the opposition. This is the first time in Wisconsin history that kind of militarization was seen in the context of an ongoing conflict between an indigenous population and an entire community that was opposed to the mining project. This was not the only dimension of the opposition. The Water Quality Authority of the Bad River Ojibwe and the opposition of local townships and communities, because with the support of the Lakuta Ray Ojibwe tribe, Paul de Maine, one of the people of Oneida background, established a harvest and education camp on public forest land in the Pinocchio Hills as a gesture of solidarity with the Bad River Ojibwe tribe. The camp is within the ceded territory where the Ojibwe have treaty rights to hunt, fish, and gather. And here you have the LCO Lakuta Ray Harvest Camp expressing the solidarity of the entire Ojibwe Nation. There are 6 Ojibwe nations in Wisconsin. Lakuta Ray is one of those 6 Ojibwe nations that was opposed to the iron ore project at the Pinocchio Hills next to the Ojibwe, the Bad River Ojibwe. And this camp was a demonstration of the importance of the natural resources of the area that had sustained the Ojibwe over several generations. This is the territory they sold to the federal government in the treaties of 1800, but for which they retained the rights to hunt, fish, and gather on, and provided their subsistence over many generations. This harvest camp educated the non-Indian public about all the resources that would be adversely affected by the proposed mine if the Pinocchio Hills were transformed into a mountain clearing operation, which essentially took the top off the Pinocchio Hills to get at the iron ore in the depths of the Pinocchio Hills, generating mountains of mine waste that would flow into the Ojibwe's wild rice beds and eventually into Lake Superior. And here's where the issue becomes an international issue, because what happens in Wisconsin is a microcosm of the larger movement of indigenous people to defend their lands and resources from unwanted mining and extractive resource projects. And so while laws defining indigenous rights vary by country, free, prior, and informed consent, which is one of the catchwords in the 2007 United Nations Declaration on the Rights of Indigenous People that was passed by the United Nations in 2007, which affirmed the right of Native peoples to protect their lands and resources and to require, as a condition of any kind of intervention by extractive resources, that there be free, prior, and informed consent prior to any kind of activity of extractive resources on Native or indigenous lands. This is evolving as the international norm governing development projects in indigenous communities. This is a worldwide phenomena, and certainly the struggles that I've already talked about regarding Wisconsin fed into the evolution of this norm of protecting Native lands and affirming the right under international law and international treaties to protect those resources. So here you have a photo from a plebiscite in Guatemala, where there is a lot of proposed gold mining activity, and free, prior, and informed consent has become an important organizing tool in indigenous communities in Guatemala. 2/3 of the country of Guatemala is made up of indigenous people. And so when those communities organize themselves and exercise their right to require free, prior, informed consent, that is a powerful signal to the international mining industry that this project does not have the support of the indigenous population and therefore is in violation of international law and international treaties. In Guatemala, at the period we're talking about in the 1990s and early 2000s, there were 65 so-called consultas or plebiscites, referendums, that have been held about mining projects on indigenous land. More than 1 million people have expressed their opposition, mostly out of concern over water pollution and its devastating impact on agriculture. Despite arguing that the votes are not legally binding, the government was forced to suspend new metal mining licenses for 2 years to stop massive indigenous protests. And so these communities that had historically been ignored when decisions were made by the Guatemalan government about giving mining concessions to companies that never consulted the indigenous population, this is the first time that indigenous communities essentially told the government of Guatemala, you can give all the permits you want, but if you don't have the support of the local community, there will be no mines on indigenous territory. The mining industry realizes that controversial projects can be stopped dead by local people and communities, threatening shareholder value and destroying executives' careers. And the reason that they realize this is because of what is known in the industry as a social license to operate. This is a term that has come out of these plebiscites, these referendums, these grassroots movements that have opposed mining corporations, where the countries or the host governments have granted mining permits without the consent of the local population, and the local population has objected, and those objections have effectively either stopped the project entirely or convinced shareholders and investors that this is too risky a project to continue to invest their money in. And so a social license means a local community's acceptance or approval of a company's presence and activities. It is intangible and unwritten and cannot be granted, in this case, by the Michigan Department of Environmental Quality, where there is proposed open pit mine next to the Mominee River on the Michigan-Wisconsin border, and it cannot be granted by any other state agency or legal authority. In other words, the final say about these projects are not in the hands of bureaucrats and the legal system. The final say is in the hands of local communities. That's the message of a social license to operate. And just so you understand that this is not something that was made up by the environmental or the native rights community, Ernst & Young, which is one of the major consulting firms that advises the international mining industry on their investments, they have assessed the key risks facing the mining industry in the year 2020 and suggested that a social license to operate was the most significant challenge mining companies face. And thus, here you have number one threat to new mining investment, according to the mining industry consultants themselves, is the social license to operate. The Mominee Nation water protectors, Mominee Nation, by the way, is the tribe whose origins are in Menominee River. Menominee River on the Michigan-Wisconsin border. There's a city called Menominee. The Mominee Nation homeland was in the area of the proposed mine. And in the 1840s, they were forced out of the state of Michigan to their present reservation in Wisconsin, but their original village and their burial grounds and their sacred territory is still in Michigan, at the mouth of the Mominee River, where this proposed mine, this open pit zinc and gold mine has been proposed. And so the Mominee Nation water protectors have joined with local citizens, environmental and sport fishing groups in both Michigan and Wisconsin in persuading towns, counties, and tribes to pass resolutions opposing the Back 40 metallic sulfide mine. And Menominee County, Michigan, which is the headquarters of the proposed Back 40 mine, the place where the local government has the most direct impact on the project, voted 5-4 to oppose the project. In other words, the very people that are supposedly going to benefit from a proposed mine in their community are the same people that are now voting against having that mine in their community. And this is a depiction of the inter-ethnic alliance that has opposed the Back 40 mine. These are the people in the blue shirts and some in the yellow shirts that have the T-shirts, "Save the Menominee River" and "No Back 40 mine." In recent years, there's been a significant increase in the number of production stoppages and confrontations at mines relating to social license to operate. On this particular photo, no social license, our home is not a gas field. One of the places where this is a particular calling card, a particular rallying cry, is in the area of Western Pennsylvania, where the natural gas industry is conducting hydrofracking operations that have contaminated well water and surface waters around these fracking sites with toxic chemicals, radioactive materials, and drilling fluids that have affected the health of the people in the surrounding communities. Both the health of the adults as well as the children have been adversely affected by the toxic materials that have been unleashed from fracking operations in Western Pennsylvania. In March 2017, El Salvador became the first country to impose a nationwide ban on metal mining. Legislators overwhelmingly voted in favor of the ban, claiming that the country's dwindling clean water supply could not sustain metal mining operations. If you look at the controversies around new mining projects in, both in the United States and around the world, the number one issue that has resulted in the mobilization of opposition to these projects is the impact of these mining operations on water. Mining operations require large amounts of water to process the minerals. They release large amounts of water contaminated from the chemicals used to separate the gold and the copper from the other waste rock. And the end result of these operations is massive contamination of both groundwater and surface water around these mining operations. And therefore, the country of El Salvador became the first country in the world to ban metal mining because of the impact on their water. That means that traditional opposition parties of the left and right came together to agree that this is a major threat to the water and the health and the livelihoods of people in El Salvador. And of course, these examples have spurred other states, other communities to take similar protective measures inspired by the success of these plebiscites and these social referendums. And so in May 2017, the Maine Senate and House in the state of Maine passed a bill that bans large open pit mines, prohibits underwater storage of mine waste, and requires companies to set aside money to clean up their contamination. Senator Everett Carson, a Democrat in Maine, said the bill would ban the most polluting form of mining in our country and the kinds of wastewater impoundments that have failed and led to environmental disasters like the Callahan mine in Brookville, which is now a federal Superfund site. The Environmental Protection Agency has declared that metallic sulfide mining is the most toxic industry in America. It produces the most toxic waste and produces the largest health threat to the communities in the vicinity of these mining operations. While there has been well-organized, significant opposition to a mining project, this is a quote from Business for Social Responsibility. In other words, this is a business lobbying group that advises the mining industry. And what they said in 2003 was where there was well-organized, significant opposition to a mining project, no matter what the prevailing laws, politicians were reluctant to go against it. In fact, global companies are under greater pressure to respond to broader social expectations today, regardless of the prevailing legal structure, than at any other time in history. And these communities on the right side of the screen are all communities that are directly downstream from the proposed Back 40 mine on the Mominee River that have passed resolutions opposing the Back 40 mining project because of the pollution that will be discharged into the Mominee River at the headwaters that flow through northeast Wisconsin down to Green Bay and eventually discharge into Lake Michigan. And if those contaminants at the headwaters of the Mominee River in Menominee County, Michigan, were to be discharged all the way down to Green Bay into Lake Michigan, it would threaten the drinking water of 10 million people who depend upon Lake Michigan for their drinking water. And of course, the Great Lakes, Lake Michigan, is the largest of the Great Lakes. It is connected to the other Great Lakes, and therefore is a threat to the entire Great Lakes system, which is the largest freshwater body in the world, containing 20% of the world's fresh water. In January 2020, the Mominee Nation declared the Mominee River has inherent and legal rights, including the right to naturally flourish, exist, regenerate, and evolve, and the right to abundant, pure, clean, unpolluted water. This notion of rights of nature is the recognition that our ecosystems have rights, just as human beings have rights. Rather than treating nature as property under the law, rights of nature acknowledge that nature in all its life forms has the right to exist, persist, maintain, and regenerate its vital life cycles. For indigenous cultures, this is simply what is so and consistent with their traditions of living in harmony with nature. And here you have the poster, which calls attention to the several demonstrations of the Menominee people to walk from the Menominee Reservation in Shawano County, or actually Menominee County, Wisconsin, about 60 miles north to the site of the proposed Back 40 mine in Menominee County, Michigan, to affirm their connection with the river, with the water, and with the sacred obligation of the Menominee tribe to protect that water, because that is the origin story of the Menominee people. In other words, the creation story of the Menominee people originates in the headwaters of the Menominee River in Michigan. So, to summarize a lot of what we've been talking about tonight, indigenous struggles to defend their lands, cultures, and the resources have redefined the balance of power between the extractive resource industry and affected resource communities. All right, 10 years ago, no one would have predicted that local organized grassroots resistance could have stood up to the power and the money and the influence of the international mining industry, their lobbyists, and their shareholders. And this is exactly what the situation is today. But now we have a genuine realignment of the power relationship between local communities and the international mining industry as a result of these expansionary struggles to defend lands and waters led by indigenous people in alliance with their non-Indian and non-native neighbors. So first of all, indigenous people have the right to participate in decision-making and to give or withhold their consent to activities affecting their lands, territories, and resources, or rights in general. This is affirmed in the General Declaration on the Rights of Indigenous People passed by the United Nations in 2007. Secondly, consent must be freely given, obtained prior to the implementation of activities, and be founded upon an understanding of the full range of issues affected by the activity or decision in question, hence the formulation free, prior, and informed consent. In other words, these traditional ways of doing business with Native peoples, where the Native peoples are told, this is the project that will happen on your land, that is a thing of the past. Not only is it a thing of the past, but Native nations now demand that before any decision is made about future extractive activity, that they have the right to access the information necessary to evaluate the social, economic, and cultural impact of these projects on their territories with the most sophisticated technical and scientific resources available to them. Number three, the legal government, which has traditionally awarded the right to mine, is no longer sufficient. A mining company must have the approval, the broad acceptance of society to conduct these activities. There's a license which cannot be provided by civil authorities, by political structures, or even legal system. This is the basic notion of a social license to operate, which is something that is beyond the bureaucrats and the legal system to either give or withhold. This is a province of the affected community. Finally, in a first of its kind lawsuit from a tribal nation in the United States, the White Earth Band of Ojibwe is pursuing a rights of nature claim in tribal court to oppose a state approval of Enbridge's Line 3 pipeline replacement. Minnesota has appealed the law in federal court. This is a rights of nature case which involves the right of Mominee. Mominee is the Anishinaabe word for wild rice. Wild rice is an essential part of the culture of the entire Lake Superior Ojibwe nations. And the proposed Enbridge oil pipeline that goes from the Alberta tar sands to refineries in the Midwest and the South would go through hundreds of streams and river crossings, potentially spilling toxic oil into the lands and waters that nourish the wild rice of the White Earth Band of Ojibwe. And so they're saying that Mominee or wild rice has an inherent right to exist, flourish, and be protected from contamination, so that it can provide the basis for the sustenance of the White Earth Band of Ojibwe. So finally, from Chief Oshkosh, Aldo Leopold, Senator Gaylord Nelson, and Walt Brissett. In case you have never heard of Walt Brissett was a Red Cliff Ojibwe tribal activist, very active during the Ojibwe spearfishing conflict, that essentially affirmed the right of the Ojibwe to exercise their federally guaranteed treaty rights to hunt, fish, and gather off the reservation, and also proposed an amendment to the Constitution which would protect the health and the economies of the communities in northern Wisconsin and around the Great Lakes from the depredations of extractive mining activities. In other words, the right to a clean environment was one of the innovations that Walt Brissett put forward in the aftermath of the treaty controversy in northern Wisconsin. And of course, the final word is given to the anthropologist Margaret Mead, who said, "Never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it is the only thing that ever has." And with that, I will close and open up for whatever questions or comments you may have. Yes.
Are these good news stories told in media or film or art, books, to make it more widely accessible?
There is two dimensions to your question. Is it widely accessible? And the question and the answer is not, because the mainstream media has a bad case of historical amnesia about these success stories. And of course, the companies that have been defeated, like the Crandon mine and the Gedicks mine, have a vested interest in assessing the responsibility for their defeat, not because of grassroots environmental and tribal opposition, but because they were stymied by regulations from the Environmental Protection Agency, or they were misled about the science of wetlands, all of which is diverting attention from what they know precisely well to be true, which is that were it not for this united opposition, none of those issues of wetlands and water quality would have arisen and become a mobilizing point for the opposition movement. And so it is up to the people involved in these grassroots movements. And that's why I quoted Rob Danson, one of the poets of the movement against the Gedicks mine in Pinocchio Hills, who wrote poetry. And he's the one that took the picture of that armed security guard in the forest. And once he posted that picture on the internet, that became a rallying point for the opposition to the Gedicks project and the militarization of the conflict. My own involvement in these struggles has been documented in several books. I've produced several movies on these issues. One of which was called Keepers of the Water, about the opposition to the Crandon mine and the involvement of the Mole Lake Sikagan Ojibwe. Another one is called Anishinaabe Niji, which is Anishinaabe for Friends of the Chippewa, which is about the opposition of the Lakuta Ray tribe and the community of Ladysmith to the proposed, the actual mine that was permitted in Rusk County in the 1990s, called the Flambeau Mine Project, which was a very small mining gold and copper mining project right on the banks of the Flambeau River that is continuing to pollute the Flambeau River with contaminants from the operation of the mine. And I should also add, as a way of keeping this before the public, I was part of a group, Wisconsin Resources Protection Council, which sued the company responsible for the pollution, Rio Tinto, which is the second largest mining company in the world, for violations of the Clean Water Act. And in 2001 or the early 2000s, Judge Barbara Crabb in Madison ruled in favor of our suit, accusing and proving that the company discharged pollutants into the Flambeau River in violation of the Clean Water Act. And immediately, Rio Tinto, one of the largest mining companies in the world, turned around and appealed to the Short Court of Appeals in Chicago. The Court of Appeals overturned Barbara Crabb's decision, not because there wasn't pollution, but because they argued the state of Wisconsin had granted them a permit to do what they did, and therefore they couldn't be held responsible for polluting the river. So not only was a setback to the issue, but then the company turned around and sued the Wisconsin Resources Protection Council for the legal costs of suing them in the first place. So when you talk about trying to get the word out, there's an enormous wall of opposition and silence that descends very quickly as soon as you have these kind of victories, and so it becomes an obligation of those who have participated in those struggles to keep alive, those stories, because those are the stories that need to be told and that would never be heard unless the people that were involved continue to do that.
There's a question online that's asking, have there ever been any educational curriculum required for schools in Wisconsin to educate their students on this history?
Well, there is Act 31, which is the requirement that came out of the spearfishing controversy in recognition that much of the opposition to the exercise of treaty rights by the Ojibwe were based upon misinformation or total lack of information about what a treaty right is and how that affects the management of the resource. And so after the end of the spearfishing controversy, or at least the legal end of it, in 1992, it was a requirement passed by the legislature that in several grades, in the elementary grades like 5th grade and 7th grade, and then 1 year in high school, that there be units devoted to a description of the Indian tribes of Wisconsin and the notion of treaty rights. But that does not necessarily go to the issue that you raised, which is what about the significance, of the opposition to the Grandin mine, to the Pinocchio Hills mine, to the Route 40 mine. There's no curriculum that addresses that issue.
Al, I have a question on a topic we talked about when you came and visited my class. I'm wondering if you can speak to whether or not with each one of these victories, they're kind of an accidental byproduct where the companies or the minerals have to go resource somewhere else. Or whether or not we keep seeing that every time one area gets protected, another area perhaps more marginalized is then going to be exploited in turn.
Yeah, I mean, this is the classic counter argument put forward by the mining industry. They tell a community that if you don't let us mine here in Wisconsin or Michigan or Minnesota, where you have strict environmental laws that protect your water and the air from excessive pollution, we're going to go somewhere else in Democratic Republic of Congo or El Salvador or Zimbabwe, whatever, where they don't have these kind of protections, and we will reap the kind of environmental devastation that would never be allowed in the more advanced democratic societies in North America or Europe. The fact of the matter is, they're going to do that anyway. All right? These companies could care less whether they deal with a democratic government in Wisconsin, which can be bought and sold as it was under Governor Walker with the Gedicks taconite mine, or South Africa or the Congo, where they employ child labor. As long as they can get away with it, they will do that because that is the most cost-effective and profitable way of doing mining. So the notion that they have some kind of conscience, they would rather do it in a protected environment versus an unprotected environment, is simply their propaganda line.
Any other questions?
Are there places in the United States where there have been kind of big losses, where some of these big mines have been able to get in face of community outrage?
So you're asking whether there have been significant losses in these battles.
Yeah.
Well, let me think. Well, I mean, there's so many places where there's ongoing opposition, where the battle has been going on for decades, like in the Oak Flats region of Arizona and New Mexico, where Rio Tinto is proposing a copper mine on sacred Apache land that's been in the courts, for the last decade, and that's unresolved. And you have the Alaska gold and copper mine in Bristol Bay, and that's been going on for 20 years. The Environmental Protection Agency has recently decided that the environmental impact statement that was produced several years ago did not take into account the entire impact of the mine on the fishery, the salmon fishery of the Bristol Bay area, which is a major source of the fresh salmon in North America and the subsistence of the Alaskan tribes. The biggest defeat, or at least what appears to be a major defeat, of course, is Standing Rock in North and South Dakota, where Enbridge has successfully engineered an oil pipeline that goes through the Sioux territory and affects other tribes under Lake Ojai, which is part of the Missouri River system, which is the source of the drinking water for the Standing Rock Sioux and other tribes. The project was disapproved under Obama, and then as soon as Trump came to power, he reversed that decision and allowed the Corps of Engineers to bypass doing a full environmental impact statement, which allowed the pipeline to go through. But now the appeals court has ruled in favor of the Standing Rock Sioux that the environmental impact statement that did not take into account their treaty rights needs to be redone to address that question. And they have asked the court, because the impact statement was fraudulent or was incomplete when the permit was granted, that the project be halted until the legal issues are resolved. The court has denied the request of the tribe to enjoin the Enbridge pipeline from continuing to operate. So it's still operating, but there's still a court case which may eventually result in the denial of the permit. So I think that's the biggest example of what appears to be a major defeat of the grassroots opposition. But of course, the significance of Standing Rock is not confined to the Enbridge pipeline. The Standing Rock was the first time that the international indigenous community mobilized around the world to come to Standing Rock to take a stand against this illegal, unwarranted, destructive pipeline, and withstood a major assault by private military, by local police, where they were assaulted with rubber bullets, with concussion grenades, and where there was mass arrests of peaceful protesters who were handled as if they were eco-terrorists, which was the propaganda line promoted by Tiger Swan, which was the private military corporation employed by Enbridge Pipeline, whose experience defeating insurgencies in Afghanistan and Iraq became the basis for assaulting and surveilling the population at Standing Rock. Nonetheless, despite all that repression and despite all the severe suffering that took place by people that were simply exercising their rights to oppose an illegal pipeline, that example has spread to other pipeline battles, and the pipeline that would have gone through Virginia and Tennessee has been withdrawn because of the same kind of opposition that was generated by the Standing Rock protest. And so even though Standing Rock is still somewhat of a standoff, the example of Standing Rock has inspired other successful anti-pipeline protests, which are, of course, directed at the fossil fuel industry and the urgent the urgent demand to limit greenhouse gas emissions, which are a threat to all plant life, animal life, and human life on the planet.
Wondering if you could say more about the rights of nature law. I know that it's exciting that, well, I think it's exciting that it's presenting a framework that's really different from a lot of our Western notions of property and human. But a lot of very different from our Western notions of property and human ownership. But it would also be a tectonic shift in how we would think of creating policy language that would still then, like, who would have the right to speak for the river or to be able to bring a lawsuit on the role of the river, and how would penalties be enacted? So I'm just curious from your viewpoint, having been a part of these legal battles for a long time, what do you see as the opportunities that a kind of rights of nature law provides, and what are its potential weaknesses?
Well, I mean, the example I gave of the white earth Ojibwe arguing rights of nature from the Newman has been put forward by lawyers for the white earth tribe, who are arguing in tribal court, which is their right as a sovereign nation to adjudicate that issue. And that is still ongoing, even though the initial ruling of the court was that it is outside the jurisdiction of the court, but that was based upon a misunderstanding of this distinction between the White Earth Reservation and the White Earth Territory, because White Earth Territory is the lands that the Ojibwe depend upon to harvest wild rice that are part of their treaty rights going back to the 1800s, where they sold lands to the United States government, but reserved the right to hunt, fish, and gather in those ceded lands. And so that territory is still relevant in the legal framework of the federal treaties that were negotiated with the Ojibwe Nation. So that's still ongoing. The most recent case that I'm aware of where there's been some advancement of the whole mechanics of rights of nature is in Ecuador. And of course, Ecuador is the ground zero for rights of nature, because about 10 years ago, the government of Ecuador passed a rights of nature provision that is now part of their constitution, that governs the entire legal structure of Ecuador. And because of that provision in the Ecuadorian constitution affirming the rights of nature, any mining company now that wants to proceed with a project in Ecuador has to demonstrate that it is in accord with the provisions in the Constitution to protect the nature that will be affected by their operations. And that has thrown the entire international mining industry into a tizzy, because they have never contemplated a situation where they have to defend their operations against a very well-crafted rights of nature provision in a sovereign nation's constitution. And so there is essentially a delay or a standoff between the international mining industry and the government of Ecuador because of that provision of rights of nature. The city of Toledo has passed the rights of nature resolution to protect Lake Erie from contaminants from industries around Lake Erie. That has been challenged in local courts, but there's ongoing arguments to defend rights of nature because of the urgency of the water supply in Lake Erie, which has been under siege for the past 10 years, and particularly from toxic algae infections that have essentially created a health hazard for people that draw their drinking water from Lake Erie. So the urgency of rights of nature has to be understood as a direct response to the even greater urgency of global warming, which is affecting all these other ecosystems and putting those ecosystems and the people that depend on those ecosystems at risk. And so legislative and legal initiatives that were seen as unrealistic and unachievable even several years ago because of the most recent reports of the International Panel on Climate Change and their warnings about the urgency of taking immediate action to reverse global greenhouse gas emissions, that has essentially elevated the importance of rights of nature lawsuits. So, the bottom line, even if the lawsuits have failed, even if one succeeds, it sets an example for other communities, and it makes it more likely that other communities facing similar challenges are going to file other lawsuits that will learn from the mistakes that were made in previous versions of rights of nature laws. In other words, there's going to be a gradual, a very advanced learning process in filing and being successful in achieving the objectives of rights of nature lawsuits.
So in situations, situations where rights of nature are passed in cities or in countries, are those laws primarily progressive, like they only affect future projects, or is there precedent there for them to take apart like past mines or operations?
They would only affect future projects.
Only future.
Just real quick, I mean, clearly this is a subject you have some passion about. What got you involved?
I was a graduate student in sociology in Madison in the 1970s, and I was primarily involved in opposing U.S. Intervention in Latin America, particularly the attempts to overthrow the Allende government in Chile, which had nationalized American copper companies in the face of a history of the gross mismanagement of the resources of the Chilean economy, which depended overwhelmingly upon the revenues generated by copper revenues from their extensive copper mining operations. And because of that, I was invited to a conference in Racine, Wisconsin in 1976 called Indian Tribes as Developing Nations. And the basic idea of Indian tribes as developing nations was based upon the idea that just like the oil-producing countries got together and formed a cartel to raise the price of oil and to get better terms between the oil-producing countries and the oil companies, Indian tribes sat on lands that contained vast amounts of untapped energy and mineral resources, and it was about time that these resources be recognized not simply as exploitable, but as part of the treaty rights of indigenous nations. And at that conference, and I think, is Dan here? Dan Polar in the back there. Why don't you stand up for a second? Dan was a member of the Mole Lake Tribal Council, and him and his brother approached me. This was 1976 when Exxon first proposed the Crandon mine next to the Mole Lake Reservation, and they asked me to help them oppose the project. And I thought that was a reasonable request until I talked to other environmental groups around the state to get them to support Mole Lake Tribe, and they told me that we can't do that. We can't do that. We can't oppose Exxon because this mine is going to happen. Exxon is a powerful corporation. The governor is in favor of it. The legislature is in favor of it. The regulatory agencies think it's inevitable. You're going to lose, and we're going to lose our credibility as environmental organizations that depend upon rich donors from the upper and middle class to support our lobbying activities. So we got the support of no environmental groups in the state. It was just Mole Lake and myself. And so I put together a research firm called COAC Research to do an independent environmental, social, economic analysis of the Exxon mine next to the reservation. I recruited graduate students from economics, from biology, botany, political science, archaeology, anthropology, to do an extensive analysis of the Exxon Crandon project. And the first thing that we did was we challenged all the assumptions that Exxon had made about the benevolence and responsibility of the company that wouldn't possibly harm the wild rights. They had told us that the discharge from the mine would never affect the wild rice. And so one of the first things the tribe did was they got the U.S. Geological Survey to do a dye test. And they put dye in at the headwaters of where the mine was going to be located. They traced the dye. And according to Exxon, any contaminants from the mine would go around Wild Rice Lake. It would not affect the wild rice. What happened was, of course, if that were to be the case, it would be the first time in hydrological history where water followed the dictates of a corporation. The dye didn't go around the edge of Wild Rice Lake. The dye went through the entire lake, disproving Exxon's major contention that the wild rice was safe for mining. And as soon as that happened, the tribe was able to bring that information to the local community, which had been, for the most part, supportive of the mine project, and develop an alliance between the Mole Lake tribe and the surrounding community. So the long and short of your question, how did I get involved? I was recruited because I knew something about how mining operations in Chile did not benefit the people of Chile. And in fact, when the government of Chile elected a democratic socialist government under Allende in 1970, the first thing the mining companies did was they organized a boycott of Chilean copper on the world market, trying to strangle the Chilean economy. And eventually, in 1973, that government was overthrown in a violent military coup supplied by the Anaconda and Kennecott Mining Company, along with the Central Intelligence Agency, instituted a military dictatorship, which arrested and tortured thousands of people over a 20-year period and lasted until the late 1990s.